transact the business which was created. All persons having business for this court draw near, give attention, you shall be heard. God save the United States, the state of Tennessee, and this honorable court. Criminal Court Judge Sandra Dogany, Chancellor Casey Colbreth, and Chancellor Patricia Head Moscow presiding.
All right. Thank you. And that's Judge Donaghy.
Thank you.
No problem. All right. Good afternoon. Welcome to Davidson County Chancery Court Part 1 for today's hearing before three-judge panel assigned by the Tennessee Supreme Court. I'm Chancellor Pat Moskal. I serve the 20th Judicial District in Davidson County, where this lawsuit was filed. Joining me on the panel are Criminal Court Judge Sandra Donaghy, serving the 10th Judicial District, representing the Eastern Division of Tennessee, and Chancellor Casey Colbreth, serving the 25th Judicial District, representing the Western Division of Tennessee. Today is March the 5th, 2026. The case called for hearing is number 23-1196, Part 1, and the style of the case is Allyson Phillips versus State of Tennessee. Before we proceed, I do want to remind all participants that today's hearing is being live streamed at the ongoing request of the public and the media. We thank the Tennessee Administrative Office of the Courts for making arrangements for today's live stream. We welcome those who are watching via live stream on the Tennessee 10 Courts YouTube channel. And because the hearing is being live streamed, I want to remind all participants, including our panel judges, to be sure to speak into your microphones for better audio quality. I would now like to ask one attorney from each side to introduce yourself and your co-counsel who are participating in today's hearing with you today. Who do we have for the plaintiffs?
Good afternoon, Your Honor. Linda Goldstein of the Center for Reproductive Rights for the plaintiffs. I'm joined by my colleagues, Nicholas Cabot and Alexandra Willingham, also of the Center, and Alex Lawrence of the Morrison and Forster firm, and Scott Tift of Barrett Johnston. And I will be arguing the summary judgment motion.
All right, thank you. And for the defendants.
Good afternoon, Your Honor. Jenna Adamson from the Tennessee Attorney General's Office on behalf of state defendants. I'm joined by my colleague, Stephen Griffin, who will be dividing time with me, and by my colleague, Zach Clark.
Ms. Adamson, I'm going to have to ask you to either turn up your volume or move a little bit closer to your microphone.
Certainly, Your Honor.
You're not coming through quite as loudly as we need to be able to hear you. All right.
Is this better?
Yes.
Okay, great. Thank you.
All right. Thank you. Today's hearing is not an evidentiary hearing, but is oral argument on defendant's motion for summary judgment. We will first hear from defendant's counsel for their opening argument, then plaintiff's response argument, and then defendant's rebuttal argument. The panel has imposed a 60-minute time limit for argument by each side, including the rebuttal arguments on behalf of the defendants as the movement. Please do not feel obligated to use all 60 minutes if you do not need it. And please also know that to the best of our ability, we have attempted to review the motion, the response, and all of the documents that have been submitted in support. We would ask if you are referring to a specific exhibit during your argument, if you would please identify that exhibit by exhibit number. After argument is concluded, the court will take defendant's motion under advisement to allow the three judges on the panel to confer on our ruling, and we will issue a ruling as soon as we are able to do so. The court has a few preliminary matters that we would like to touch on, and then I will ask each side if you have any preliminary matters. First, I just want to review, there's been a number of motions filed, and I want to just review what motions are currently pending filed by the parties and we are in the process of preparing orders on those motions. Defendant's motion for clarification or reconsideration on the court's October 16, 2025 motion to compel. The plaintiff's motion for sanctions regarding the maternal mortality data. We have multiple motions for leave to file documents under seal. The court has reviewed those motions and we have reviewed the responses, the last of which we just got in the other day. And we will enter orders on those motions and provide instructions regarding the filing of redacted versions of those materials. I do want to mention that there are very few circumstances where it's appropriate to file an entire memorandum of law or statements of undisputed material facts, the entire document under seal. And the parties are requested on the front end to do a preliminary review and file redacted versions, so that as much is in the public docket as can be. We, on that point, we have some concerns that the confidential material has been over-designated, and we are going to ask that that be reviewed before we conclude our orders on these under seal document. And one issue in particular, I'm going to direct to you, Attorney Goldstein, is on the plaintiff's designation of the materials of Doctors Monty and Andreessen. It is the panel's position. We have conferred on it, and it is our collective position that there's been over designation of some of that material. And what we would suggest is that you review it. And we're talking about both of those doctors' treatment of other patients. And you've done a good job. I did not see any patient names in the deposition excerpts or the interrogatory responses or the declarations. And but some of that information the panel believes should be in the public record as to the procedures that they performed. What we would suggest is that the plaintiff review what you have currently designated as being requested under seal, and invite you to redact dates of procedures and hospital facilities where those procedures were performed, but that the description of the procedure itself be not redacted. And if you would like to respond to that, I'm happy to hear from you. But I think that would help protect any potentially identifying dates or places, even though their names are already not available in those excerpts. Do you have any comments or questions about that, Attorney Goldstein?
No, that's quite clear, Your Honor. I guess my only question is, my recollection is that we did not include actual dates or months. So the only dates that would appear would be years.
Years, that's
So
correct.
We'll be permitted to redact the years.
Yes.
Okay, thank you.
And we will issue an order regarding that, an interim order regarding that procedure. And since some of those materials were filed by the defendants, we're going to have to ask the plaintiffs and defendants to get together and agree that the documents have been properly redacted before they actually get filed in the public record. That's the way we ordinarily handle that.
If I might, Your Honor.
Yes.
We have not, defendants filed their reply papers. Well, they weren't filed, they were submitted under seal entirely.
Right.
And we have not responded to their sealing motion because we thought it would be more efficient to wait for the court's orders on the first two rounds before trying to identify what documents should be designated confidential in those filings. Is that acceptable to the court?
Of course, that would be just fine. And you don't need to file a formal written response unless there's something that has not previously been addressed. We assumed that they were of the same nature.
Thank you.
So correct us if we made an incorrect assumption there.
No, that's correct as far as I can recall.
Okay. Okay, very good. We also have under advisement defendant's motion to exclude expert testimony. And I am now going to turn to defendant's counsel and ask you to clarify. Are you requesting exclusion of expert testimony from on both the motion for summary judgment and at trial? And if not, we need you to specify which expert you are moving to exclude as to whether it's on the motion for summary judgment or trial. If you could just be very succinct about that. It was less than clear to us from the papers.
Your Honor, I'll defer to Mr. Griffin on this point.
All right, Miss Attorney General Griffin.
Good afternoon, Your Honor. We are not arguing that the motion to exclude experts has to be granted with respect to any of the plaintiff's experts in order for the court to grant summary judgment as to each of the claims asserted by the plaintiffs in this case. We are asking that the court exclude testimony from each of those experts to the extent that this case ends up going to trial.
So it's only directed for purposes of trial.
That's right, Your Honor.
Okay, very good. Thank you for that clarification. As you could tell from one of our interim orders requesting the plaintiff's response, it was not clear to the court. And so thank you for that. And then the last motion that we still have under advisement is the plaintiff's third motion to compel discovery. So have we overlooked anything? I'm going to ask counsel for the plaintiffs. Does that cover all motions?
That covers all motions. We ask that the motion to compel that hearing be waived and that the motion be considered expeditiously. So we would request the court issue an order scheduling responsive papers.
Have I overlooked any motions from the defendants?
No, defendants, you covered all of defendant's substantive motions, Your Honor. We did have two pending motions for pro hoc vice admission of Ms. Meehan and Ms. Rogers and submitted proposed orders for those. But
we have those proposed orders, and we did not get confirmation until this morning that the BPR fees had been paid. And so we will get those orders circulated to the panel members, and upon approval of all panel members, we will get those orders filed. Were you anticipating having either of those two attorneys presenting any argument today?
No, Your Honor. They do intend to appear at the pretrial conference. And we did have one item we wanted to clarify with the court about the pretrial conference, if I may.
All right.
Please go ahead. We have one member of our team and potentially one other who has a conflict with the pretrial conference that cannot be moved. Would the court like us to file a formal request for her to be excused? Or is there another way the court would like us to proceed?
You can just inform the panel members right now, and because the panel had a conflict come up that was unavoidable, we apologize for changing the date and the time. So if you'll just let me know who there will be plenty representatives of each side present, since we have so many attorneys of record in this case, that I'm sure you can fill in anyone who has to be absent. Who are those attorneys for the defendant who now have a conflict?
Yes, Your Honor. So I know that Jessica Burke has a conflict. I believe that she is the only one. If there is another attorney, we will notify the court as soon as possible.
if you'll just contact either Allie Herman or Marvin Williamson and let them know if you have someone who is unable to attend, just so that we can keep track of who's present and who's not.
We will do that. Thank you, Your Honor.
Attorney Goldstein, are you aware of anyone who we have now created a conflict for?
I believe there is somebody, Your Honor, although I don't off the top of my head recall who that is. So we will
Okay,
forward
that's
that
fine.
information to Mr. Williamson and Ms. Herman.
That would be great if you would do that so that we're ready to go at the pretrial conference. All right. And be sure and bring all of your questions about how we're going to proceed at trial. We'll try and cover everything proactively, but if you've got specific questions, please be prepared to address those at the pretrial. And at my direction, just to streamline things, and I'll repeat it again here, for purposes of the trial, if you have any requests for resources during trial, please direct those through Allie Herman, who is the 3-judge panel coordinator, and so that all requests go into one person, and then she will be the point person to redirect those requests as needed to any other personnel, either at the administrative office of the courts or at the Davidson County trial courts. The administrative office of the courts is the general administrative support for 3-judge panels, but since the trial is taking place in the Davidson County courthouse, we will also be using some of our Davidson County courthouse administrative staff to support the trial, support you, and support the judges. All right. Thank you. I think that covers all of our preliminary matters. Sorry that took a little bit longer than usual, but I appreciate your patience. Is defendant's counsel ready to proceed with your motion?
Yes, Your Honor.
Okay, you may do so, and it's now 2:35.
Your Honor, we will reserve 15 minutes for rebuttal time on the end.
Okay,
May it please the court.
you may proceed.
Thank you, Your Honor. May it please the court. The statute at issue in this case is a criminal abortion ban. The legislature enacted it to prevent elective abortions. That's because, as reflected in our state's constitution and other laws, Tennesseans believe that life begins at conception and should be valued and protected from that point forward. The challenge statute does not deny mothers treatment for life-threatening and serious health-threatening medical care, which is at issue here. The General Assembly added the medical necessity exception in 2023 to ensure that doctors did not deny that kind of care, and it amended the exception in 2025 to make the exception's purpose of protecting maternal life even clearer. By its plain text, the statute protects the mother's right to life, and in support of enacting the medical necessity exception, Tennessee legislatures argued the exception protects 2 lives, the mother's and her baby's. It's no wonder then that plaintiffs' claims fail both on justiciability grounds and on the merits. My friend on the other side will doubtless cite heavily to the court's pleading stage opinions denying in part our motions. But we are at summary judgment now. That means plaintiffs must come forward with specific facts that could lead a rational trier of fact to find in their favor. Plaintiffs cannot meet that burden for standing or on the merits, so their claims should be dismissed for lack of justiciability, or the court should grant defendants summary judgment on the merits. I will first address justiciability, focusing on standing for the purposes of this hearing, and then plaintiffs' right to life and pregnancy-based equal protection claims. My colleague, Mr. Griffin, will then address plaintiffs' vagueness and mental health claims. Starting with standing. This is plaintiff's burden to prove, And at the summary judgment stage, they have to prove every element of the 3-element standing test with specific facts and details. Patient plaintiffs can only establish standing to pursue an injunction or declaratory judgment by proving an imminent future injury. The Tennessee Supreme Court's decision in Wygant, which this court didn't have the opportunity to apply before, made that clear. It held that if the plaintiff is not presently suffering an injury, the injury faced must be imminent. And it said that means that it must be, quote, likely to occur soon, not just at some unknown future time. But plaintiffs in their response brief do not cite Wygant at all. They much less try to distinguish it. Instead, their standing theory rests on past claimed injuries plus subjective future fears, but they cite no authority supporting that standing theory. To the contrary, the body of standing case law that Wygant incorporated holds that past injuries alone do not suffice to establish standing to seek prospective relief, which is what plaintiffs seek here. I expect my friend on the other side to argue that plaintiffs have proved that Tennessee doctors regularly deny or delay providing medically necessary abortions, that these plaintiffs were injured because of that other women have been injured because of that, and that patient plaintiffs thus justifiably fear the same thing will happen in a future pregnancy. Defendants contest that characterization of the evidence, but even if patient plaintiffs could prove all of that, the U.S. Supreme Court's decision in City of Los Angeles versus Lyons shows why that proof comes up short. There, the plaintiff alleged, very similarly to the plaintiffs here, that local police had stopped him and subjected him to an illegal chokehold. He alleged that that was a routine practice of the police. He alleged that numerous other people had been injured in the same way. And he alleged that as a result of those facts, it was objectively reasonable for him to fear the same thing would happen to him in a future police encounter. What did the Supreme Court say about those allegations? It said they did, quote, nothing to establish a real and immediate threat that the plaintiff would again be stopped by an officer or officers who would illegally choke him into unconsciousness. And here, plaintiff's injuries are even more speculative. They rest on a 3-step causal chain, and at best, only a handful of plaintiffs have established even the first link, pregnancy. And if the court will allow me, I'd like to share a demonstrative for this portion of my presentation.
That's fine.
Okay, thank you, Your Honor. 1 second.
Have you shown this demonstrative to the other side?
No, Your Honor.
We have not, Your Honor. Ms. Goldstein, are you able to see the demonstrative as well as the court?
I am, but I would appreciate the chance to see it before you show it to the court.
Ms. Goldstein, you may make any objection to it.
Thank you.
Your Honor, I will proceed.
Please do.
So this chart is, except for the 3rd column, is pretty much identical to a chart that we provided in our opening brief. It just shows patient plaintiffs' proof related to standing. And so at best, as you can see in the column on the far right side, only a handful of plaintiffs have established the first link in their causal chain, which is pregnancy.
And you've added a column to that chart that was not in your brief, correct?
That's correct, Your Honor. It's the 3rd column. Is patient's condition covered by the 2025 statute? But that's consistent with our arguments. It's not a new argument. It's just summarizing the information we've previously presented. No plaintiff has presented evidence that the 2nd step the causal chain is likely to happen. That is, that any plaintiff is likely to develop a life or health-threatening medical condition for which an abortion is within the standard of care. And you can see from the fourth column, that's the later healthy pregnancy column, how speculative that is. Every plaintiff who has gotten pregnant since the pregnancy at issue in the complaint has carried a healthy pregnancy to term. So to put that more simply, no plaintiff has presented evidence that she is imminently seeking an abortion. And no plaintiff has identified specific doctors who would be likely to overcomply with the statute and deny or delay in providing an abortion, even though the medical necessity exception covers the situation. And column 3, which is the new column, shows that. So it shows that the law now expressly covers the conditions involved in 3 of patient plaintiffs' cases. Again, that's an argument we've been making for a while now. And it also, and so that shows that it's entirely speculative that a future doctor would deny any patient plaintiff an abortion in the same or similar circumstances under the 2025 version of the law. And it is undisputed that the law as currently written does not allow abortions for the life-limiting fetal anomalies that the remaining 3 plaintiffs' babies experienced. So those facts don't support standing either. As the Sixth Circuit put it in Lee, someday actions without concrete details do not establish an imminent injury as a matter of law, nor do they establish causation. Plaintiffs have failed to present specific facts and concrete details proving their injury is sufficiently likely in the near future. Because that's what Wygant requires to establish standing, all patient plaintiffs' claims must be dismissed. Now moving on to physician plaintiffs. They
Are you finished with this demonstrative exhibit?
I plan to continue using it, Your Honor. I have a few more slides if that's all right, but I can also take it down until I get to that point if you would prefer.
I would prefer. I think it would be easier if we could. And Ms. Goldstein, if you have any objections to lodge, please so note, and so that I can ask you to put those on the record.
Yes, Your Honor. I mean, we disagree with the relevance of much of that, and I could not read the individual entries, so I don't know if I have any objection to the accuracy of any of the entries.
All right. I was having difficulty reading it as well. I think we're probably all on our laptops, and it's difficult to see. If you would like to submit any written objections after today's hearing, I'm going to ask defendant's counsel to provide you by email or otherwise a set of the slides that she has referred to during her argument, and you can file any written objections with the court so that we know what the grounds are. Will that work?
Yes, thank you, Your Honor.
And
All right.
we're happy to share the slides with opposing counsel, Your Honor. Your Honor, may I continue?
Yes.
So moving on to physician plaintiffs, as I said, they also must show an imminent injury to establish standing. And as they concede, their burden is to satisfy Slattery's 2-part test for showing a pre-enforcement injury. That means that, again, they must establish with specific facts and concrete details that they intend to engage in prohibited conduct under the statute. And they must establish, again, with specific facts and concrete details, a credible threat of prosecution, meaning one that is certainly impending. So taking these one by one, plaintiffs have failed to establish with specific facts that they intend to engage in a course of conduct prohibited by the statute. Both physicians practice at Ascension St. Thomas, a Catholic hospital. So their practices going forward, which is all that matters for purposes of prospective relief, are governed by Ascension's ethical and religious directives for Catholic healthcare services. Those directives prohibit abortion. That is, they provide that, quote, the directly intended termination of pregnancy before viability or the directly intended destruction of a viable fetus is never permitted. And so opposed is the Catholic Church to the termination of human life without serious maternal risk that the directives even prohibit prenatal diagnosis, quote, when undertaken with the intention of aborting an unborn child with a serious defect, unquote. In order to establish standing then, physician plaintiffs would have to prove with specific facts that there are abortions that Section 3915-213 would prohibit them from providing, and that the directives do not already prohibit them from providing those specific abortions. That's a tough ask. Physician plaintiffs have to show that Tennessee's medical necessity exception is stricter than the Catholic Church's opposition to abortion. It's no wonder then that Plaintiff Monty's opposition declaration cites not one example of an abortion the Ascension Ethics Committee would have allowed her to perform, but that Section 3915-213 would have prohibited. And Plaintiff Andreessen's opposition declaration identifies one case in which she denied an abortion at Ascension. But she attests that Ascension's Ethics Committee refused to approve abortion care for this patient. And it is undisputed, this is from Plaintiff's statement of additional material facts, that the Ethics Committee advises physicians on whether a specific case of proposed abortion care is permitted by the ethical directives. So that case provides no evidence that Plaintiff Andreessen would provide abortions in specific circumstances under Ascension's Catholic directives, but for Section 3915-213. Nor, as we explain at pages 12 to 13 of our reply brief, do any of plaintiff's other sources support that point. Because physician plaintiffs have failed to establish the first prong of Slattery's pre-enforcement injury test, their claims must be dismissed. But even assuming they could establish that prong, they have not produced the evidence to meet their burden on the second prong, showing a credible threat of prosecution that is certainly impending. And again, Wygant informs what certainly impending means, and that authority was not available for the court to reference in ruling on our motion for judgment on the pleadings. Wygant says certainly impending means likely to occur soon, not just at some unknown future time. But physician plaintiffs have no evidence of enforcement. I'll repeat. Physician plaintiffs have no evidence of enforcement. Neither of the defendant boards has received a single complaint about a physician related to Section 3915-213. That's Defense Exhibit 14, the Baca Chavez deposition at pages 33 and 51 to 52. Tennessee's District Attorney Generals have received no complaints about alleged violations of the challenge statute. That's Exhibit 15, the Crump deposition, page 29, nor has any district attorney investigated or prosecuted any alleged violations. That's also the Crump deposition at pages 28 and 29. And the Attorney General has not exercised his statutory authority to petition the Supreme Court for appointment of a district attorney pro tem to prosecute offenses under Section 3915-213 in the almost 4 years since Dobbs. In fact, General Scrimity has never used that authority to enforce any statute, much less this one. That's Exhibit 16, the Sutherland deposition, pages 21 to 22. nor has defendant Scrimetti received any complaints or initiated any investigations of physicians for alleged violations of the abortion statute. Same deposition, pages 22 to 23. Now, I recite all of that evidence of non-enforcement, but I emphasize that the burden is on plaintiffs to present evidence of enforcement. And all they have is arguments that some defendants have authority to enforce Section 39-15-213. But if that were all it took to establish pre-enforcement standing, the credible threat of prosecution prong would be meaningless. Any plaintiff could sue any state defendant with authority to enforce the statute, regardless of whether prosecution was certainly impending. Wygant and Slattery make clear that's not the goal. Instead, as plaintiffs concede, the Court of Appeals has adopted the Sixth Circuit's multi-factor test for showing that prosecution is certainly impending. And under that test, plaintiffs must show some combination of the factors being met. And a history of past enforcement is an especially important factor in that analysis. Physician plaintiffs do not even attempt to argue that they have evidence of a credible threat of prosecution under that framework by the state. So their claims against the state should be dismissed. As to defendant boards, physician plaintiffs merely point to those boards' statutory authority to, quote, deprive them of their licenses, unquote. But again, just having statutory authority is not enough to establish a credible threat of prosecution. So plaintiffs' claims against the boards must also be dismissed. Finally, physician plaintiffs do attempt to establish two of the Slattery factors as to General Scrimetti, but their first attempt relies on a press release that just cited to Section 39-15-213B's bar on abortion as context for General Scrimetti's enforcement of a different statutory provision. And if the court looks at the press release, that's clear from the text of the press release. Second, plaintiffs argue that General Scrimetti has refused to disavow enforcement of the statute via his pro tem appointment power. But the Sixth Circuit has made clear that if that's your only factor, that's not enough to establish a credible threat of enforcement. In fact, it has said that the sort of refusal to disavow here, where General Scrimetti has said that, as plaintiffs themselves say, this statute could apply in a wide variety of circumstances and it's highly fact dependent. So he's not going to disavow prosecution in unspecified circumstances. The Sixth Circuit has said that that does not suggest a credible threat of enforcement as a matter of law. So alternatively, because plaintiffs have failed to prove that enforcement is credibly threatened and likely to occur soon, they lack standing and their claims must be dismissed. And then very briefly, because plaintiffs concede at 31 of their opposition brief that AMA's standing turns on whether Mani and Andresen have standing, AMA's claims must also be dismissed. Now, a very brief word on plaintiffs standing to assert their mental health-based equal protection claim. Plaintiffs respond nowhere in their opposition brief to defendants' argument at pages 15 to 16 of their summary judgment brief that patient plaintiffs lack standing to assert the mental health-based equal protection claim. Under the Court of Appeals decision in Domini, that means they have waived any argument that they have standing to assert that claim, and the claim must be dismissed. Even if plaintiffs plan to argue that physician plaintiffs have standing to assert that claim, neither physician plaintiff has said that she actually would use abortion to treat any mental health conditions. Instead, they have both attested that they simply have patients with mental health conditions, which is a very different thing, as my colleague, Mr. Griffin, will get into more on the merits. And then second, plaintiffs concede that any claim on behalf of the patients is advancing someone else's rights. And a plaintiff must have an injury done to him to get into Tennessee courts under Wilmington Trust. Plaintiffs can't explain how enforcing someone else's rights falls under that rubric. So plaintiffs lack standing to assert their mental health claims. And because plaintiffs don't have standing to assert any of their claims, the complaint should be dismissed. Now, I'll just very briefly touch on the right to life and equal protection claims. Putting the right to life claim in its simplest terms, plaintiffs argue that Section 3915-213 violates patient plaintiffs' right to life in practice by causing physicians to deny or delay the medically necessary abortions. There are several problems with this. I'll just touch on the two biggest. One is that the statute protects the mother's right to life. And it's significant for strict scrutiny purposes, though we don't think that standard applies, that plaintiffs never explain how the statute could be more narrowly tailored to protecting that right than it is. In other words, how could the statute more explicitly say that physicians can perform abortions to save lives than to say a physician may perform an abortion necessary to prevent the death of the pregnant woman?
Well, doesn't that turn on the standard that is baked into the statute, that it's a reasonable medical judgment rather than the physician's best judgment within the standard of care?
Your Honor, it's the physician's reasonable medical judgment based on the facts presented at the time. Physicians operate under their reasonable medical judgment all the time. And plaintiffs haven't explained how that the fact of the reasonable medical judgment overlay somehow undercuts the statute's explicit provision for life-saving abortions. And I don't have the site at my fingertips, but I believe plaintiff's expert, Dr. Zucker-Wise, said that she understood the statute would allow her to provide an abortion if the mother's life was in danger. And I'm happy to provide that site on rebuttal if that would be helpful, but I believe we cited it in our opening brief. And then the only other thing I'll say about that claim is that plaintiffs can only state a due process claim against the state if the actions of the doctors who are actually causing the injuries are fairly attributable to the state. But again, we argue that the statute expressly allows life-saving abortions. So if the doctors are denying patients life-saving abortions, they are disregarding the statute's protection for life. And so the state action doctrine bars their right to life claim. And then very briefly on equal protection, the pregnancy-based claim. In order to show an equal protection violation, plaintiffs must establish that the two classes involved are similarly situated in all material respects as it relates to the law's purpose. No one disputes this law's purpose is to save babies' lives. Even if plaintiffs think that it goes too far and harms mothers, they can't dispute that purpose. And as it relates to that purpose, it is material that an abortion terminates the life of the baby, the second patient, whereas other medical treatment, other medically necessary care does not. And even if plaintiffs could cross that similarly situated threshold, they have the burden of negativing every conceivable basis, which must support the challenged distinction between pregnant patients and everyone else. And whether they have done so is a question of law that the court may answer and must answer without weighing whether the General Assembly could have drawn the line at a different point or more narrowly to serve a different interest. And as defendants explain at pages 41 to 46 of their reply brief, plaintiffs have failed to satisfy their burden to refute any of the rational bases, much less all of them, that the state has offered to support the law. So the court should grant defendants summary judgment on plaintiff's pregnancy-based equal protection claim. And unless the court has any questions for me on those portions of the argument, I will turn it over to Mr. Griffin.
Please do.
Thank you, Your Honor. I'll just briefly address the equal protection mental health claim as well as the due process vagueness claim. Summary judgment should be granted on plaintiff's equal protection mental health claim for two independent reasons. First, the evidence in the record clearly demonstrates that pregnant patients with mental health conditions are not similarly situated in all material respects to those with physical conditions when it comes to seeking abortion. But even if they were, the legislature's decision to make this distinction in the statute will easily satisfy rational basis review, which everyone agrees applies here. So first, just addressing the first threshold requirement of being similarly situated. They must be similarly situated in all material respects. And to be material, that means that that similarity must relate to the purpose of the law being challenged. That's a threshold issue for any equal protection claim under Tennessee law. The classes created by the mental health exclusion in this statute are not similarly situated in all material respects with respect to seeking abortion. First, Your Honors, the record demonstrates that abortion is an accepted treatment for serious physical conditions that threaten the life or health of the mother. But the evidence also shows that abortion is not an accepted treatment for any mental health condition. The plaintiff's own experts admitted this during their depositions. And I'm just going to briefly share my screen.
Is this an excerpt? Have you shared this with plaintiff's counsel prior to today's hearing?
Your Honor, this is just an excerpt from the deposition.
You need to tell me the exhibit number and the page number, please.
Yes, Your Honor, this is exhibit number 13 to the defendant's motion for summary judgment. This is page 38. This is Dr. Zuckerwise's deposition. And as we've highlighted in our summary judgment briefing, Dr. Zuckerwise was asked specifically about this during her deposition. Dr. Zuckerwise is a maternal fetal medicine specialist. She's someone who actually performs abortions, or is someone who would if they were presented with the condition that qualified. She was asked, have you ever performed an abortion intending to treat a patient's mental health condition? And Dr. Zuckerwise said, abortion is not the treatment of a mental health condition. And when she was asked about that further, if the court looks down at lines 14 through 18, Dr. Zuckerwise said that a patient who has psychiatric disease, performing an abortion will not take that away in the same way it won't take away someone's cancer and won't take away someone's diabetes. The plaintiff's mental health expert that they retained, Dr. Payne, she said something similar. She was asked, this is, Your Honors, this is at the very bottom of the screen, but this is Defendant's Exhibit 12. This is the deposition of Jennifer Payne at page 93. She was asked if she was aware of any academic literature that advocates using abortion to treat a patient's mental health condition. And she said very succinctly and candidly, I'm not. She was asked right after that, are you aware of any medical organizations or groups that advocate using abortions to treat a patient's mental health conditions? Again, she was very candid and said she is not aware of any such organizations that advocate using abortion for that purpose. The plaintiff's argument in their response is that, well, Dr. Payne says abortion may make a patient's outcome more positive in terms of managing a psychiatric disorder. And so women with mental health conditions ought to have the same access to abortion as those with physical conditions. Their only evidence for that, Your Honors, is the testimony of Dr. Payne, the psychiatrist in Virginia that they retained as an expert in this case. But when Dr. Payne was asked if she has any research or literature to support her assertion on that, again, she was very candid and said, no. If the court will look at the screen, this is, again, Defendant's Exhibit 12, Dr. Payne's deposition at page 94. As it pertains to this argument that the plaintiffs make that, hey, patients with serious mental health conditions should have the same access to abortion as patients with physical conditions, she was asked, are you aware of any specific research or academic literature that supports what you just said? She said, I am not. Your Honors, just to make sure, she was asked again, so you haven't done any research specifically, or you're not aware of any research into whether pregnant patients' mental health conditions should be treated via abortions? And she said again, very candidly, I'm not. Going beyond the deposition testimony of plaintiff's own experts, we also cited in our summary judgment briefing recently published guidelines from the American College of Obstetricians and Gynecologists This is not attached as an exhibit to our briefing, Your Honors, but we did cite the article. We gave the site, which is down at the bottom of the screen. This is 141 American College of Obstetricians and Gynecology, 1262, at pages 1263 through 81. This was a publication from 2023. And Your Honors,
Is that
I'm sorry.
cited in your brief?
It is,
Is
Your
that
Honor.
cited in your brief? At what
Yes.
page?
I'd have to pull that up, and I can get Your Honor's answer to that question.
I just want to make sure that it has been properly cited so that plaintiffs had knowledge that you're relying on that.
Yes, Your Honor. It was cited in our briefing. I'm happy to produce the page number. I just don't have that up in front of me at the moment. Your Honor, this article, this practice guide from ACOG. I'm sorry. This practice guideline from ACOG is a 27-page guideline for the treatment of mental health during pregnancy. It analyzed treatment of depression, anxiety-related disorders, bipolar disorder, and acute psychosis for women during pregnancy or within 1 year postpartum, including conditions that either predated the pregnancy or that came on for the first time during the pregnancy itself. The guideline has extensive discussion of treatment options that included the use of medication or psychotherapy. But Your Honor, ACOG never even once mentioned that abortion would be an option for treating a mental health condition. In the 27-page single-space document that
So are you asking this court to review ACOG practice guidelines and draw some conclusion from it without any medical expert testimony to explain it to the court?
Your Honor, we're presenting this for the mere fact, in the vacuum of evidence that exists in this case for the plaintiff's mental health claim. We're presenting this as yet another example of the fact that providing abortion for mental health conditions is not something that's accepted in the medical community, even though ACOG, which the plaintiffs cite all throughout their complaint as the nation's leading professional association for obstetricians and gynecologists, the largest such association in America, has put out this practice guide for OBGYNs just in 2023. And despite addressing all of these psychiatric disorders that women may experience during pregnancy, it never once mentions abortion as an option. That's just to demonstrate, Your Honor, that patients with mental health conditions seeking abortion are not similarly situated to patients with physical conditions. Abortion is an accepted treatment for one. It's not an accepted treatment for the other.
Is this in your statement of undisputed material facts?
Your Honor, I don't have the specific site in front of me, but I'm happy to provide that. I believe we did address that in our statement.
Because what the court needs, the court needs to view this through the summary judgment analytical framework. And you're offering this, asking the court to draw a conclusion from it, but it, to the extent there are any facts in here that you're asserting that the court should rely on, we need to know where that is in your statement of undisputed material facts, and whether it's disputed or not by the plaintiffs.
Thank you, Your Honor. And just to circle back, we did cite the ACOG practice guideline at page 49 of the opening brief, opening summary judgment brief.
I have that site. Thank you.
Thank you, Your
I
Honor.
found it while you were discussing it.
You're way ahead of me. Your Honor, the plaintiffs respond and say, well, the ACOG mental health guidelines really address mild to moderate cases, and that in severe cases, the patient should be referred to psychiatrists or other mental health professionals. And that honestly proves the point, Your Honors, because psychiatrists don't perform abortions. They provide therapy or medication for mental health conditions. Your Honor, the plaintiffs can't point to literally any evidence at all that abortion is an accepted treatment for mental health conditions. And that's only borne out by the evidence related to the actual practice of the physician plaintiffs, in our case, Dr. Mounty and Dr. Andresen. They have both told us in discovery about multiple physical conditions that they have treated using abortion. But as Ms. Adamson mentioned earlier today, neither Dr. Mounty nor Dr. Andresen has ever performed an abortion to treat a mental health condition, nor have they ever said they're even willing to do that. The fact that they may have patients who suffer from mental health conditions is a completely different question than whether they actually use abortion to treat those conditions. And the evidence in the record demonstrates they don't. The court didn't have the benefit of any of this evidence at the pleading stage when it was faced with the dispositive motion under Rule 12, but it has it now. And Your Honors, if that weren't enough, we've also cited literature in our brief that there's no objectively verifiable criteria for diagnosing mental health conditions, which is not like most physical conditions, which do have objectively verifiable criteria. And that changes the calculus when it comes to determining whether or not termination of the life of an unborn baby is actually warranted. That's just another material distinction that shows the lack of similarity between patients with mental health conditions seeking abortion and those with physical conditions. Your Honors, Tennessee's appellate courts in Shaw versus Metro Nashville.
Can I interrupt? I'm sorry, Mr. Griffin. Can I interrupt you again?
Yes,
When
ma'am.
you say there's no objective verifiable criteria to diagnose mental health conditions, is that in your statement of undisputed material facts?
Your Honor, I'd have to look back at the
Okay.
statement to identify if there's a specific, which number that is.
Okay, thank you.
Your Honor, as I mentioned, Tennessee's appellate courts, Shaw versus Metro Nashville, City of Memphis versus Hargett, others have all said that this requirement of similarity is a threshold requirement for any equal protection claim under Tennessee law. Since the plaintiffs have not carried their evidentiary burden on that threshold issue, the mental health equal protection claim should be dismissed now at the summary judgment stage. Similarity aside, even assuming that pregnant patients seeking abortion for mental health reasons are similarly situated to those seeking abortions for physical conditions, the mental health exclusion in Tennessee's abortion statute easily satisfies rational basis review, which is the standard that the court must apply here. The Tennessee Supreme Court has framed this as a deferential standard. Under rational basis review, if any state of facts can reasonably be conceived to justify the classification, or if the reasonableness of the classification is even fairly debatable, the statute must be upheld. And we've cited Harrison, Tennessee Supreme Court case from 1978 in support of that. The plaintiffs are the ones who have the burden here to negate every conceivable basis which might support that distinction drawn by the mental health exclusion. I'm not sure that it can be overstated just how high of a burden that is for the plaintiffs to overcome at summary judgment. This is a question that can and should be resolved here at the summary judgment stage. The plaintiffs are the ones who have the burden to demonstrate that there is no open debate about this question. Not only have they not done that, but they haven't presented evidence indicating that a debate even exists. We just talked a few moments ago about the fact that it's well acknowledged in the medical community that abortion is not a known or established treatment for mental health conditions. It's not recognized by ACOG, which the plaintiffs say is the leading professional association for OBGYNs in the United States. Dr. Zuckerwise, their maternal fetal medicine expert, says abortion is not a treatment for mental health conditions. And Dr. Payne, again, admits that there's no research or literature or even any medical organizations that say abortion should be used to treat a mental health condition. There's no evidence in the record otherwise. And so it's certainly reasonable and rational for the General Assembly to take a policy position and exclude abortions as a permitted treatment for mental health conditions. All that the plaintiffs have pointed to is the testimony of Dr. Payne that abortion should be available as an option for severely psychiatrically ill patients. Even though she admits she has no research or other scientific basis to support that, and despite no medical organization out there agreeing with her on that. But again, Your Honors, the standard here is rational basis review. And the Tennessee Supreme Court says that means that the reasonableness of that distinction must only be fairly debatable. I'm not sure that a debate between one paid expert witness and the rest of the entire medical profession would actually constitute an open debate. But even if it did, Your Honors, debatable policy choices like this satisfy rational basis review under binding Tennessee law. The Tennessee Supreme Court in Harrison and numerous other cases that we've cited say that if the distinction that's drawn by the legislature is fairly debatable, then the court has to uphold it. The United States Supreme Court said the same exact thing just last year in United States versus Scrimetti. Your Honors, to deny summary judgment on this issue, the court would have to look at all the evidence in the record and determine, no, the plaintiffs have shown that this isn't even debatable, that the legislature's decision to draw this line was completely irrational. And Your Honors, the plaintiffs clearly haven't even attempted to do that. The mental health claim based on equal protection should be dismissed here at summary judgment. We've also argued in our briefing that the state has an interest in protecting prenatal life, as the Supreme Court recognized in Dobbs, and limiting abortions to only serious physical conditions that threaten the life or health of the mother does exactly that. The plaintiffs have argued in response that if the mother commits suicide, well, both she and the baby would die. But again, the plaintiffs haven't produced any evidence whatsoever that abortion prevents suicide. And Dr. Payne, their psychiatry expert, admits that she has no evidence to support that. Your Honor, the mental health exclusion also furthers Tennessee's interest in preserving the integrity of the medical profession. Again, this goes back to the fact that there's no evidence that in the medical community, abortion is an effective treatment or even an accepted treatment for mental health conditions. And Your Honor, again, like we've talked about in our briefing, the rationality of the mental health exclusion is also supported by history and modern practice. There's simply no evidence that mental health abortions were historically protected, and numerous other states currently have adopted the same restrictions on mental health abortions as Tennessee has. Again, this is rational basis review, and the law has to be upheld if the reasonableness of the classification is merely debatable. There's no question that the mental health exclusion satisfies that standard. Plaintiffs have to prove that there's no conceivable rational basis for the law, and they haven't done that. And so we're asking the court to grant summary judgment on that claim. Finally, Your Honors, I'll just briefly address the due process vagueness claim. The court's already dismissed the physician plaintiff's claim that the abortion statute is vague on its face. And that's because the legal standard for facial vagueness is that the law is unconstitutionally vague in all its applications. And as the court properly recognized, the medical necessity exception does have clear applications, and so the facial vagueness claim is gone. All that we have left is the physician plaintiff's claim that the abortion statute is impermissibly vague as applied to them. And Your Honors, it's important to understand exactly what that means under Tennessee law. In an as-applied vagueness challenge, the plaintiffs have to demonstrate that the statute is vague as construed and applied in actual practice against the plaintiffs as to their specific conduct. The physician plaintiff's due process vagueness claim can't survive summary judgment for at least two reasons. First, Tennessee law does not recognize an as-applied vagueness challenge in the pre-enforcement posture that we're in this case. It's undisputed that no one has ever enforced or even threatened to enforce the abortion statute against either of the physician plaintiffs or any other physicians in Tennessee for that matter. The Tennessee Supreme Court in State versus Burkhart said that if a statute is not facially vague, in other words, if it's not vague in every application, then Tennessee courts, quote, will not consider in advance of application all possible contingencies of attempted prosecution under a criminal statute and declare which are constitutional and which are not, close quote. Plaintiffs have not cited a single Tennessee opinion that says you can bring an as-applied vagueness challenge before the law has ever been applied. We've looked and we have not found any either. They cited one circuit court order in their response brief in the case of Anderson versus Metro Nashville, but that case involved a challenge to a Sydney ordinance that was brought after and not before the plaintiffs in that case had been denied permits that they had sought under the ordinance they were challenging. And that circuit court order said nothing about whether you can bring an as-applied vagueness challenge to a criminal statute before the statute has ever been applied. The federal court cases that recognize a pre-enforcement as-applied vagueness challenge have all implicated constitutionally protected conduct, mainly speech under the First Amendment, which obviously is not implicated here. And so, Your Honor, since there has been no enforcement against the physician plaintiffs or anybody else in Tennessee under the statute, the physician plaintiffs can't meet the requirements of Burkhart for bringing an as-applied vagueness challenge in this pre-enforcement context. The court can and should grant summary judgment for that reason alone. Second, Your Honors, the physician plaintiffs cannot demonstrate that the medical necessity exception is unconstitutionally vague as applied to them in their practice. And so just to briefly reiterate, Your Honor, For this type of claim, we look at two things. What does the evidence say about the extent of Dr. Mounty and Dr. Andreson's actual practice with respect to abortion? And so for that, we have their testimony about their past abortion practice, both before and after the trigger law took effect. And we have the abortion policies of Ascension St. Thomas, which is the Catholic hospital where they are currently employed. And so the court must then ask whether Tennessee's abortion statute is unconstitutionally vague as applied to them in their actual practice. And Your Honors, that's a purely legal question that must be answered by the court using principles of statutory construction and applicable case law. Courts don't determine vagueness in the due process context by counting how many doctors on one side say the law is vague versus how many doctors on the other side say it's not. That's not how constitutional vagueness claims work. This court has already recognized that when it denied a motion to compel discovery that asked for communications of various individuals about their own understanding or interpretation of the statute. And so, Your Honors, the declarations that were submitted by the plaintiffs from themselves and other doctors saying that they think the statute is vague are completely immaterial. To the extent those declarations are also based on hearsay from other doctors, they're inadmissible regardless. We would point the court to the Tennessee Supreme Court's opinion in State versus Crank, where the Tennessee Supreme Court said that courts must construe the statute to ascertain and give effect to its legislative purpose. To do that, the court has to give statutory terms their plain and ordinary meaning. And this court has a duty, even here at summary judgment, to construe the statute in a way that resolves any doubt in favor of the constitutionality of the statute. Crank also made clear that the Constitution does not require absolute precision in statutory drafting, especially given the inherent vagueness of words used in the English language. So in Crank, the Tennessee Supreme Court upheld a criminal child abuse statute and its spiritual treatment exemption, despite the plaintiffs in that case arguing that statutory terms were unclear, and despite the statute providing no examples of the type of conduct permitted. That makes the case that we're dealing with here an easy vagueness case. The abortion statute clearly prohibits elective abortions, and it sufficiently conveys that physicians are permitted to terminate a pregnancy to protect against serious risks to the life or health of the mother. The fact that the statute now contains examples of the types of conditions permitted by the medical exception just makes the case all the much easier. Based on the evidence we have about Dr. Andreson and Dr. Mounty's practices at Ascension, we know that Tennessee's abortion statute has clear applications to the vast majority of medical risks that they encounter in their specific practices. We've included charts in our reply brief, Your Honor, that sets out the types of medical conditions that they've said that they performed abortions for in the past or that they wish to perform abortions for. That includes ectopic pregnancy, molar pregnancy. Those things are excluded from the definition of abortion in Tennessee's abortion statute. They've also identified spontaneous miscarriage, and the statute excludes the removal of a dead fetus from the definition of abortion. They've identified pre-viable pre-prom, severe preeclampsia, cervical insufficiency. The statute now clearly says that all those things qualify within the medical necessity exception. Even hemorrhage that is life-threatening. Again, the statute allows an abortion to prevent the death of the pregnant woman. But the physician plaintiffs say—
Mr. Griffin, I just, I'm being the time monitor now. I've already let you run over about 5 minutes. Could you wrap up your principal argument?
Yes, Your Honor. The physician plaintiffs say that, hey, we might encounter other patients who have conditions where the application is not quite as clear as it is in those particular scenarios. But again, that's not sufficient to establish a due process vagueness claim. And hypothetical future cases are especially an opposite in an as-applied challenge. The statute does not have to clearly identify every scenario in which conduct is permitted. Crank and other cases have all made clear that every statute is going to have close cases. The fact that a statute uses terms that are of general meaning and have close cases is simply not enough to establish a due process vagueness claim. The plaintiffs say, well, there's concerns about when abortions can be performed, but that's why the statute includes the term prevent. And the court should apply the ordinary meaning of prevent to conclude that a doctor doesn't have to wait until death or bodily injury are imminent before stepping in. They've also said, well, the list of examples is accompanied by the word may, But Your Honor, the ordinary meaning of the term may indicates permission. In other words, these are examples of when abortion is permitted, and that gives breathing room to doctors because some of these conditions may not arise until after viability and abortion may not be warranted. Abortion is not mandatory if those conditions come up. The vagueness challenge is only further undermined by the fact that there's no evidence whatsoever of arbitrary enforcement. We know that dozens and dozens of abortions have been performed within the bounds of the statute since the trigger law took effect, based on testimony given in the case from Allyson Holland, as well as Dr. Brackney and Dr. Hauser. Yet there's no indication that any physician anywhere in Tennessee has ever had the abortion statute enforced or even threatened to be enforced against them. Your Honors, due process vagueness presents a question of law. There are no genuine issues of material fact that warrant a trial on the vagueness claim, and so we're asking the court to enter summary judgment on this claim as well. Thank you.
Thank you. All right, we will turn to plaintiffs' counsel for your response argument.
Thank you, Your Honor. I will just alert the court that I am getting several pop-up notices on my computer saying that I'm about to be booted off the computer, and my colleagues are getting the same notices. So I want to continue to carry forward.
Well, let's hope
in the
so.
hope that it doesn't happen. But nothing personal to anybody if we get kicked out, and we'll try our best to
All
fix
right.
this. May it please the court. Defendants claim in their argument that the patient plaintiffs are just outlier cases, and that the medical necessity exception to Tennessee's criminal abortion ban is not infringing the constitutional rights of other pregnant patients. Defendants also claim that the ambiguities in the medical necessity exception have been cured by the 2025 amendment to the law. But the facts get in the way of both arguments. Plaintiffs have submitted a mountain of factual evidence demonstrating widespread delays or denials of medically necessary abortion care in Tennessee. Dr. Molly Hauser, a maternal fetal medicine specialist, or MFM, in Memphis, and Dr. Lisa Zuckerwise, an MFM who formerly practiced in Nashville, testified that hospitals delay abortion care for patients with previable PPROM until they are infected or hemorrhaging. That's at paragraph 8 of Dr.
Well, it appears that Attorney Goldstein did get bumped off.
Oh,
So we'll pause for a moment and see if she can reconnect. Perhaps Mr. Tift, you might be able to reach out to her.
yes, Your Honor. I was just doing exactly that. It looks like everybody except me did get, so I'm sure they're all aware, but I've already texted them to make sure they
Okay.
realize.
We'll just stand by then.
Where's my going?
Marvin Williamson, are we ready to proceed?
Your Honor, this is Jenna Adamson. I don't see my colleague, Mr. Griffin.
I think he may be back. His video has not caught up yet.
Yes, I see him now. Thank you.
If you, we're going to stand by for just a moment until Marvin Williamson, who's hosting this Zoom meeting, lets us know he's ready to pick up where we left off.
Yeah, is the court reporter on? Because I'd like to know where I cut off.
Yes, ma'am. And you were getting ready to tell where the paragraph of that paragraph that you read last about them hemorrhaging. I was trying to look for that to see. You got the word paragraph. You may have said 8, but
It was the
Yes, okay.
Okay.
Thank you.
So Marco, I'm ready now.
all right. I believe, Mr. Griffin, were you leaving your video off? There you are. All right. We wanted to make sure we had everyone. We wanted to make sure we had everyone back. This is Chancellor Muskell. We had a brief recess. We dropped several participants from the Zoom hearing. I think we have everyone back, and the pop-up message you were receiving, Attorney Goldstein, was quite accurate. So we will start the clock over as well if you would like to either start over or pick up where you left off.
I can pick up where I left off.
Okay.
And I thank you for restarting the clock. I was going through the mountain of factual evidence demonstrating the widespread delays or denials of medically necessary abortion care in Tennessee. From Dr. Molly Hauser and Dr. Lisa Zuckerwise, who testify that hospitals delay abortion care for patients with pre-viable PPROM until they're infected or hemorrhaging. And that's in paragraph 8 of Dr. Hauser's declaration and 29 of Dr. Zuckerwise's declaration. Dr. Hauser further testifies that hospitals are declining to provide abortion care to patients with maternal conditions such as heart failure, chronic kidney disease, or a history of cardiomyopathy. Dr. Nicole Schlechter is an OBGYN who practices at Ascension Midtown Hospital in Nashville. She testifies that she has seen miscarrying patients showing up with infections or bleeding at Midtown who had been denied abortion care. That's paragraph 16 of her declaration. Dr. Sarah Osmondson, an MFM also practicing in Nashville, testified about a patient with a fatal fetal diagnosis of acrania that threatened her with uterine rupture, who was denied abortion care. And plaintiff Dr. Laura Andreessen testifies that earlier this year, she had to deny abortion care to a patient with a partial molar pregnancy and severe preeclampsia. This is not hearsay. These are the direct experiences of doctors practicing across the state of Tennessee. The evidence also shows that pregnant patients are being harmed. Rebecca Milner is one of our patient plaintiffs who developed sepsis after she was denied abortion care for pre-viable PPROM. Katie DuLong is another patient plaintiff who developed a severe infection after she was delayed in getting abortion care for cervical insufficiency. Plaintiff Heather Mowney has submitted a long list of patients she has seen who were harmed by delays in receiving medically necessary abortion care. And that the harms ranged from a patient with placenta previa and vaginal bleeding who lost her uterus, another with peri-viable PPROM who experienced septic shock, and another who lost an ovary and fallopian tubes. And that's in Exhibit 13, Dr. Mounty's interrogatories. And then there is Dr. Michael DeRoche, an MFM in Franklin, Tennessee, who says he has seen necessary abortion care delayed to the point that without immediate intervention, the pregnant woman could lose her life. Plaintiffs have submitted evidence that physicians continue to delay providing abortion care to patients with pre-viable PPROM and inevitable abortion, two of the conditions that the 2025 amendment says may justify abortion care. This evidence comes from Dr. DeRoche, who says that he himself counsels patients that they cannot get an abortion for these conditions unless they are infected or hemorrhaging. And this evidence comes from Dr. Hauser in Memphis, who regularly sees patients with pre-viable PPROM who have been told by their Tennessee doctors that they cannot get an abortion until they show signs of infection, and who has spoken directly to Tennessee doctors who also interpret the law that way. And that is admissible evidence because what she learns from her patients is an exception to the hearsay rule because it's a statement from a patient to a treating physician. And what she hears from the doctors is not hearsay because it's not true. Tennessee law doesn't bar doctors from providing abortion care to patients with pre-viable PPROM, but the doctors think it does, and that's the problem. Defendants have argued that testimony from other Tennessee physicians is irrelevant to this case, but defendants cannot have it both ways. They cannot defend this case by arguing that patient plaintiffs are outliers and then block us from proving that they are not. They cannot defend this case by saying that the 2025 amendment fixed the medical necessity exception and ended its chilling effect on the performance of abortion care, and then block us from proving that it didn't. And none of the legal authorities that they rely upon requires this court to blind itself to how the ambiguous exception to Tennessee's abortion ban is actually impacting patient care. This court has already ruled, sometimes multiple times, on the legal sufficiency of the allegations in plaintiff's complaint. Many of my friends' arguments today have focused on requiring additional elements for standing or additional substantive elements of the claims beyond those that the court has already found to be sufficient. I'm going to go through each of defendants' justiciability and substantive arguments by focusing on the evidence that plaintiffs have submitted to substantiate the allegations that this court has already found to be sufficient as a matter of law. On standing, the court is well aware of the three required elements of injury, causation, and redressability. I'll review those separately for each category of plaintiff. For the patient plaintiffs, it is undisputed for purposes of this motion that each of the patient plaintiffs was denied medically necessary abortion care. That's in defendant's response to our statement of additional material facts, number 1. It is undisputed for purposes of this motion that each of them fears being denied abortion care again in a current or future pregnancy. That's their response to our SAMF number 8. The only factual dispute on this issue is whether Rebecca Milner is capable of becoming pregnant again, which they dispute by noting that she is 45 years old and by submitting hearsay statistics on fertility rates for women of that age. On that point, the record evidence shows that Ms. Milner's physician has told her that there is no reason she could not become pregnant. And in fact, at age 45, she has a regular menstrual cycle. That's paragraph 18 of her declaration. Tennessee Code 24-5-112 recognizes that there is an absolute common law presumption which prevails in Tennessee that men and women are presumed capable of having children as long as they live. That presumption is rebuttable only by competent evidence, which the defendants have not produced. If defendants wish to dispute Ms. Milner's reproductive capacity, it has to be decided at trial on competent evidence. All of the patient plaintiffs have therefore submitted sufficient evidence of injury under the standard that this court has set out in its previous decisions. What defendants are trying to do on this motion is to re-argue that standard by pointing to additional cases, none of which have merit. In Wygant was not a case that dealt with past injury producing current fear, which is what we have. In Wygant, it was a voter redistricting case, and the voter was held to have suffered no injury at any point in time because there was no palpable and discrete impact from the renumbering of the Senate districts as a result of the redistricting. So the finding of that case had nothing to do with past injury producing present ongoing fears of future recurrence. The City of Los Angeles case is distinguishable because in that case, which was about police chokeholds, the past chokehold was an illegal act. And there was no basis to think that it could be repeated since it was not the policy of the City of Los Angeles to allow chokeholds, to the contrary. And there was no evidence that there was a practice among police officers of conducting illegal chokeholds. And here, as I started out with, there is ample evidence of widespread chilling effect of patients being denied or delayed in getting constitutionally required healthcare necessary to save their lives or preserve their health. For causation, it is undisputed for purposes of this motion that each of the plaintiff's treating physicians said that under Tennessee law, it would be unlawful for them to offer her abortion care. In fact, Plaintiff's Exhibit 1, Plaintiff Milner's medical records, it says as much in black and white in her medical record. Defendants contend that it is speculative as to whether Tennessee doctors would deny the patient plaintiffs abortion care in the future. But plaintiffs have produced ample evidence that many physicians and hospitals are telling patients that they cannot get abortion care for pre-viable PPROM until they are infected or hemorrhaging. That's in the declarations of Dr. Hauser, Dr. DeRoche, and Dr. Schlechter. If this court were to accept defendants' legal argument that plaintiffs must prove that Tennessee doctors as a class are likely to deny them care, then at most, this is an issue of fact that cannot be resolved on summary judgment. I will just briefly just say with respect to redressability, that because plaintiffs have produced evidence that physicians are withholding medically necessary abortion care because of the ambiguity of the medical necessity exception, plaintiffs have produced sufficient evidence that clarification of the law would provide redress. Turning now to the physician plaintiffs. Because this is a pre-enforcement challenge, as the court is well aware, there are two elements of establishing injury for the physician plaintiffs. The first is an intention to engage in a course of conduct arguably affected with a constitutional interest, but prescribed by statute. The record shows that Dr. Anderson and Dr. Mowney previously provided medically necessary abortion care to their patients before Tennessee's criminal abortion ban went into effect. That evidence is summarized in our Statement of Additional Material Facts number 10. The record also shows that they have denied medically necessary abortion care to their patients since the ban went into effect. That's in SAMF number 11. They both work currently as obstetric hospitalists at a major urban hospital where they can face virtually any pregnancy complication or comorbidity. That's at paragraph 19 of Dr. Mouney's declaration, paragraph 16 of Dr. Andreessen's. Finally, both physicians have submitted sworn declarations that they would be less fearful of providing medically necessary abortion care to their patients if Tennessee's abortion law were clarified. That is enough to establish an intention to engage in a course of conduct prescribed by statute. And I should add that it is a course of conduct prescribed by statute that has constitutional implications, because the care that they are denying is care by definition necessary to preserve the life or health of the patient. And that has constitutional dimensions. And the only way a pregnant patient can access medically necessary care is through a licensed Tennessee physician. Defendants contend that as a matter of law, neither physician plaintiff can establish intent to provide medically necessary abortion care because both doctors currently work at Ascension St. Thomas Midtown Hospital, which adheres to the ethical and religious directives for Catholic health services. As an initial matter, that argument has no bearing on Dr. Andreessen's standing because the relevant date for her standing is March 12, 2025, when the second amended complaint was filed. More importantly, however, for both physicians, their argument requires this court to presume that Tennessee's abortion ban has had no impact on the medically necessary care provided at Midtown Hospital. But the record evidence shows that Tennessee's law is chilling the provision of medically necessary abortion care at that hospital. Dr. Nicole Schlechter, who I mentioned before, was formerly the chief medical officer at Midtown Hospital, and she was also the physician-in-chief of women's services for the entire Ascension St. Thomas network in Tennessee. She testifies that the ethical directives, and I quote, give physicians at Midtown Hospital more flexibility to provide medically necessary abortion care than Tennessee's criminal abortion ban does. That's paragraph 9 of her declaration. Dr. Schlechter explains that the ethical directives permit procedures that under Tennessee law would be considered abortions, where the physician's direct purpose is to cure a proportionately serious pathological condition of a pregnant woman without imposing a reasonable medical judgment standard like the Tennessee statute does. And the ethical directives permit this life-saving care, even though it doesn't call that procedure an abortion. Dr. Schlechter further notes that if a physician gets clearance from Ascension's ethics committee, the abortion can be performed without any adverse consequence from the hospital. But under Tennessee's abortion ban, there is no pre-clearance, and there is no assurance that a physician who performs an abortion that is cleared by Ascension's ethics committee will not be second-guessed by a prosecutor or regulator. Further, Dr. Schlechter provides a specific example of a physician who declined to administer abortion pills that Ascension had authorized her to administer to a patient with cervical insufficiency and pre-viable pre-prom because that physician was afraid of criminal prosecution. And that's at paragraph 14 of Dr. Schlechter's declaration. Finally, Dr. Andreessen testified about a patient with severe preeclampsia and a partial molar pregnancy who was denied abortion care at Midtown Hospital earlier this year. Dr. Schlechter believes that Midtown Hospital would have provided such care before Tennessee's criminal abortion ban went into effect. So there is a fair inference from Dr. Schlechter's testimony that it was Tennessee law that caused Dr. Andreessen to have to decline providing that care, and that inference cannot be resolved on a motion for summary judgment. Defendant's assumption that medically necessary abortion care at Midtown Hospital was not affected by Tennessee law is based solely on their reading of the text of the ethical directives, without considering how the ethical directives are applied in practice at Midtown Hospital, And I would point out that's very similar to how their entire approach to this case and how they read the statute and try to ignore the actual consequences and how it's interpreted by physicians. The problem, one of the problems with this approach in looking at the ethical directives is that they're just wrong. The defendant suggested in their opening brief that the ethical directives prohibit abortion for ectopic pregnancies. They base that on their reading of the directives themselves. And Dr. Schlechter says, no, that's not right. That's never been the case at Midtown Hospital. That's paragraph 8 of her declaration. Defendant's assumption that Tennessee's abortion ban has not also chilled the performance of medically necessary abortion care at Midtown Hospital is a factual issue that cannot be resolved on summary judgment. This court has twice held, moving on to credible threat of enforcement. This court has twice held that plaintiff's allegations were sufficient to establish a credible threat of enforcement. Those allegations have now been backed up with record evidence. For the Board of Medical Examiners, the Board of Osteopathic Examination, and their members, that evidence consists of, first, the statutes that mandate both boards to discipline physicians for violations of Tennessee's abortion laws. And as this court has pointed out previously, that's a mandatory obligation. It's not discretionary. And now, in addition to that, we also have deposition testimony that the board's investigations are complaint-based, meaning that the boards are obligated to open an investigation when they get a complaint, which can be filed by anyone, any citizen, any disgruntled employee, anyone can file a complaint. This is an attribute of the challenge statute that makes enforcement easier or more likely. One of the 4 factors that the Sixth Circuit sets out in its test for determining whether there is a credible threat of enforcement. For the Attorney General and the state, the evidence of credible enforcement is, again, going back to the laws, the fact that the Attorney General has direct authority to prosecute osteopath physicians, such as Dr. Andreessen. That's 63-9-110C. The Attorney General has submitted a sworn interrogatory response in which he confirms that he said he would seek appointment of a pro tem prosecutor to prosecute a violation of the criminal abortion ban if there's a situation where a prosecution would be merited and you have a DA categorically disclaiming a desire to prosecute. So we now have record evidence of that allegation from our complaint. We also have record evidence that the Davidson County District Attorney General, where Dr. Mowney and Dr. Andreessen both now practice, issued a statement. It's available on the Attorney General's District Attorney General's website. It's Plaintiff's Exhibit 5, stating that he would not prosecute physicians for providing abortion care at patients' requests. So that is the categorical claim that he would not prosecute that the Attorney General contemplated in his statement that would trigger his appointing a pro tem prosecutor. The Attorney General has both refused to disclaim an intent to seek a pro tem appointment, and he has refused to explain the criteria that he would use to pursue enforcement. Those are located at Defendant's Exhibit number 17. Again, the interrogatory responses. And he's also refused to disclaim authority to prosecute under the osteopath statute as well. As my friend noted in her argument, the Attorney General has also issued a statement and sent letters to various retail pharmacy chains, warning them not to sell the abortion pill mifepristone in Tennessee. This was a direct threat to enforce 3915-213. I'll just point out a rather plain error that defendants made in their reply brief. They responded to this by saying that 3915-213 applies only to physicians, not pharmacies. That's plainly wrong. It applies to any person who performs or attempts to perform an abortion. So the Attorney General has plainly stated an intent to prosecute. The statutory authority, combined with the Attorney General's threats to exercise that authority and his refusal to disclaim an enforcement authority, is sufficient under the standards that this court has set out in its previous decisions. Counsel is trying to add additional elements by requiring greater specificity in the disavowal, citing a Sixth Circuit case called Christian Healthcare Centers versus Neville. That Sixth Circuit case, as far as we can find, has never been cited or relied upon by any Tennessee state court. In terms of causation and redressability, the declarations from Dr. Mounty and Dr. Anderson establish that the reason they have refrained from providing medically necessary abortion care is Tennessee's abortion ban. So that those record facts back up that allegation from the complaint. And as this court has previously held, declaratory and injunctive relief would redress physician plaintiffs' injuries. Briefly on third-party standing, the only argument that defendants have made with respect to third-party standing is that the Tennessee Supreme Court's decision in Wilmington Trust dispensed with that doctrine. This court has already rejected that argument in footnote 16 of its order denying defendants' motion for judgment on the pleadings, in which it held that Wilmington Trust said nothing about third-party standing. And then to round out standing, plaintiff American Medical Association has standing because its members, Drs. Anderson and Dr. Mounty, have standing. On ripeness, the parties agree that in a pre-enforcement challenge, the issues of ripeness and standing overlap. So there's not much more for me to say on that issue. I do want to point out that the Sixth Circuit decision in Carmen versus Yellen, which defendants fault us in their papers for not addressing, in fact, show why this case is ripe for decision. In Carmen, the Sixth Circuit held that the plaintiff had failed to establish that the case was ripe because forthcoming regulations may meaningfully narrow the challenge statute's scope and ameliorate certain of plaintiffs' claimed injuries. That's not the case here, where the Attorney General, the medical boards, and even the executive director of the District Attorney General Conference have refused to offer any guidance to physicians as to when they would prosecute violations of Tennessee's criminal abortion ban. And the statement of the executive director of the District Attorney General Conference that appears at Schlechter Declaration Paragraph 20. On mootness, the court has already held that the 2025 amendment did not cure the defects alleged in the second amended complaint. And I would just point out that the declarations we have submitted from Dr. Anderson, Dr. Mounty, Dr. Hauser, Dr. DeRoche, Dr. Schlechter, and Dr. Osmundson established the statute continues to chill the performance of medically necessary abortion care. On sovereign immunity, the one point I would make is with respect to government action for purposes of 13121. which is that the governmental action that we challenge, the enactment of an ambiguous statute, is not limited to the original enactment of the medical necessity exception in 2023. It also includes the 2025 amendment, which purported to clarify the medical necessity exception. As Dr. Hauser testifies in her declaration, many of the physicians that she works with are becoming even more hesitant to participate in abortions under the medical necessity exception because the state has not offered clear guidance to practitioners and has only enacted an amendment that is itself vague. That's at paragraph 10 of her declaration. One of the reasons the amendment is so perplexing to practitioners is that the listed conditions of PPROM and inevitable abortion, et cetera, only may fall within the medical necessity exception under the statute. But defendant's own expert, Dr. Brackney, cannot think of any circumstance that an abortion performed for any of those listed conditions, mirror syndrome, pre-viable PPROM, inevitable abortion, severe preeclampsia, would not meet the serious risk of substantial and irreversible impairment of a major bodily function statutory standard. And that's the Brackney deposition is Defendant's Exhibit 19, and those admissions are on page 188, lines 8 through 21. The fact that the statute suggests that there may be some circumstances where an abortion could not be legally performed on a patient with one of those conditions makes it inscrutable to practitioners. I'll now turn to the substantive arguments, starting with the physician plaintiff's vagueness claim. This court has already held that physician plaintiffs' allegations that they and other Tennessee physicians are chilled from providing medically necessary abortion care because of fear and confusion about the scope of Tennessee's abortion ban adequately states a claim that the medical necessity exception is unconstitutionally vague. The record facts substantiate those allegations. The physician plaintiffs have provided sworn testimony showing that they have declined or delayed providing abortion care to patients for fear of prosecution under Tennessee's law. Dr. Andreessen denied care to a patient with severe preeclampsia and 2 patients with subchorionic hemorrhage and bleeding. That's at paragraphs 10 and 17 of her declaration. She delayed providing care to a patient with massive bleeding and a patient with, I will slaughter this word, a bicornuate uterus and impending miscarriage. That's at paragraph 10 of her declaration, and Plaintiff's Exhibit 14, her supplemental interrogatory responses at page 12. Dr. Mowney denied care to a patient with a fatal fetal diagnosis of monosomy X who was at risk of developing mirror syndrome, and to a patient with cervical insufficiency. Those are at paragraph 12 of her declaration. We've also presented evidence of widespread fear and confusion in the form of the declarations I've already described. Defendants' arguments for summary judgment on the vagueness claim either raise disputed issues of fact or seek to re-argue this court's previous holding that physician plaintiffs could assert an as-applied pre-enforcement challenge. Neither is a basis for summary judgment. First, defendants argue that physician plaintiffs can't show that they face the prospect of denying medically necessary abortion care to their patients because they both work at Midtown Hospital. But as I've already discussed, the record evidence shows that Tennessee law chills abortion care even at Midtown Hospital because the statute allows for prosecution of abortion care even if Ascension St. Thomas approves it. This is an issue of fact that cannot be resolved on summary judgment. Second, they contend that the 2025 amendment clarifies nearly every condition that the physician plaintiffs have previously encountered. That was the chart in their reply brief. But this court has already held that the 2025 amendment did not cure the defects in the medical necessity exception when it denied defendants' motion to dismiss on mootness grounds. Pardon me, the motion for judgment on the pleadings on mootness grounds. And in physician plaintiffs' current practice as hospitalists, they can encounter virtually any pregnancy complication. They are not limited to the complications that they have previously seen in their prior practices. Third, defendants argue that the court cannot consider physician plaintiff's testimony on the ambiguity of the statute. But the physician plaintiff's testimony about the statute explains its unclear scope and its unclear application in the medicine that they practice. And those are the sources of the statute's chilling effect. So they are not testifying about the meaning of the statute. They are testifying about why it is that it is chilling medical care. Fourth, they argue that there is no such thing as a pre-enforcement challenge, pre-enforcement as applied challenge under Tennessee law. That's simply incorrect. The Anderson case that my friend mentioned earlier was in fact a pre-enforcement challenge. In that case, the plaintiffs sought injunctive relief against future enforcement of a municipal ordinance that barred short-term rentals of non-owner occupied property. The pre-enforcement challenge was brought after plaintiffs' request for a license had been denied, but there were no enforcement proceedings. The action was brought to enjoin enforcement proceedings, so it was by definition a pre-enforcement challenge. Next, defendants assert that the various federal cases that we have cited in our papers and that this court has previously relied upon when it held that we could assert a pre-enforcement as applied challenge arose in the context of a First Amendment speech challenge. That's not, as a factual matter, correct, because we also cited National Shooting Sports Foundation versus James, which did not involve First Amendment rights, but was a challenge by gun manufacturers to a New York public nuisance statute. As I've said before, this case does concern constitutionally protected conduct because only physicians can provide life-saving abortion care to patients under the medical necessity exception. Finally, defendants have repeated their claim that physician plaintiffs seek facial relief. This court has already rejected that argument. Physician plaintiffs have provided sworn evidence that in their current roles, they can face virtually any pregnancy complication or maternal condition. The same is true for the many AMA members on whose behalf AMA is suing in this case. Thus, as applied relief can be broad enough to encompass any kind of condition that the physician plaintiffs and AMA members would face in their practice without converting this case into a facial challenge, as contemplated by the Tennessee Supreme Court's decision in Fisher versus Hartnett. Turning now to the patient plaintiff's right to life claim. There are sworn declarations and deposition testimony from each of the patient plaintiffs describing how they were denied medically necessary abortion care. Katie DeLong was denied care after she suffered cervical insufficiency at 16 weeks. Rebecca Milner was diagnosed with previable preterm rupture of membranes at 20 weeks. Each of them was told that they could not get abortion care because of Tennessee's criminal abortion ban. Defendant's own expert, Dr. Brackney, has conceded that each of those plaintiffs should have been offered abortion care to prevent a serious risk of a substantial and irreversible impairment of a major bodily function. That's enough to establish that Ms. Milner's and Ms. DuLong's constitutional right to life was infringed by the law. For the 4 other patient plaintiffs, each received a fatal fetal diagnosis that posed a risk to their lives. Rachel Fulton's baby was diagnosed with fetal hydrops, which put her at risk of developing mirror syndrome, a potentially lethal condition. Allie Phillips's baby was diagnosed with holoprosencephaly and multiple other conditions that made her incompatible with life. What's more, the baby was in a breech position and would have to be delivered by cesarean section if she survived to term. That is significant because, as explained by plaintiff's expert Dr. Zuckerwise, a cesarean section itself is a substantial and irreversible impairment of a major bodily function, namely a woman's reproductive capacity. The same was true for Catherine Archer's daughter, who had a constellation of lethal anomalies and was in breech position, which also would have required delivery by cesarean section if she survived to term. Monica Kelly's baby was diagnosed with trisomy 13, which is a lethal diagnosis that put Monica at risk of both mirror syndrome and preeclampsia, both of which are life-threatening. Each of them was told that they could not get an abortion under Tennessee law. Rachel Fulton's doctor told her that she could not get abortion care in Tennessee until the baby died or she was in mortal danger. Plaintiff's expert, Dr. Zuckerwise, has provided sworn testimony that abortion care was necessary to preserve the life or health of each of them, and that abortion was within the standard of care for each of them. That is enough to establish that their rights were infringed by the law. This court has held that patient plaintiff's right to life claim is subject to strict scrutiny. That means that defendants must show a compelling interest to justify the infringement and that the law is narrowly tailored to further that interest. The principal interest defendants point to is fetal life. But as stated at paragraph 27 of Dr. Zuckerwise's declaration, there was no prospect of sustained life for any of the pregnancies that the 6 patient plaintiffs were carrying. In fact, Allie Phillips's baby died in utero before she reached New York for an abortion. But continuing the pregnancy put each of them at risk. The state cannot have a compelling interest in prolonging a pregnancy that has no prospect of resulting in a live baby. The state cannot ever have a compelling interest in endangering the lives and health of pregnant patients in favor of fetal life. As we noted in our brief, multiple state Supreme Courts have held that the fetal life interest does not justify endangering a pregnant patient's life or health. For the same reason, the medical necessity exception is not narrowly tailored to preserving fetal life, because it jeopardizes the lives of pregnant patients even when prolonging the pregnancy does not improve the fetus's prospects of life. Defendants' efforts to dismiss the patient plaintiff's right to life claim fundamentally misconstrue it. First, they contend that the claim can be resolved as a matter of law because the exception does protect pregnant patients' rights to life and health, that the mere existence of the exception is sufficient. But this argument is belied by the factual evidence, including the concessions of their own expert, showing that as applied, the exception does not adequately protect patients' interests. On strict scrutiny, this court must look to how a restriction on a constitutional right actually operates in fact, not just what it looks like on paper. Next, they argue that the state action precludes this claim because we are presuming that doctors will ignore the scope of the law, but we are not presuming anything. We have presented ample evidence that doctors' performance of medically necessary abortion care is being delayed or denied, and that it is being delayed or denied because of the ambiguity of the statutory language. Defendants denigrate this as mere physician over-compliance, but that is just another word for chilling effect. Defendants also argue that the medical necessity exception appropriately balances the interests of fetal life and maternal health, and that it eliminates the possibility of abortions for erroneous diagnoses of fatal fetal conditions. But defendants cannot explain why that balance cannot be made by the pregnant patient whose own life or health is at risk from the continued pregnancy. Finally, defendants assert in their papers that the medical necessity exception is narrowly tailored because the 2023 maternal mortality rate in Tennessee has dropped. We submit in our motion for sanctions that defendants should be precluded from relying upon this data because they have not complied with the court's order compelling them to produce the 2024 data. And even if that motion is not granted and they're permitted to rely upon the 2023 data, at most it raises a disputed issue of fact that cannot be resolved on summary judgment. Turning to equal protection now. This court has already held twice that patient plaintiffs could assert an equal protection claim on the theory that Tennessee's abortion ban discriminates against pregnant patients who need a medically necessary abortion. Defendants have been unable to identify any other statute in the Tennessee Code that prevents non-pregnant people from accessing essential medical treatments. It is undisputed for purposes of this motion that patient plaintiffs were denied medically necessary abortion care. That is sufficient to establish a prima facie case of discrimination. Defendants propose 3 bases that they claim as rational justifications for discriminating against pregnant patients who need medically necessary abortion care. None of them is a ground that this court can resolve on summary judgment. First, they argue that so long as there is some conceivable interest in preserving fetal life, the statute can survive rational basis review. We disagree. It is not rational for the state to interfere with a pregnant woman's right to access care that is necessary for her life or health on the theory that the state is better able to balance the maternal and fetal interests at stake than she is. The evidence in this case is that each patient plaintiff made the choice that she thought was best for her and her family. There is absolutely no rational basis to override that decision, where the record evidence shows that for each of the patient plaintiffs, the fetus would not have benefited from continuing the pregnancy. And I would submit that for other pregnant patients with high risk or complicated pregnancies who need a medically necessary abortion, there is never a rational basis to override the patient's own calculus of the acceptable risks to her life and to her health by continuing the pregnancy. Next, defendants argue that preventing pregnant patients from accessing life or health-preserving abortion care somehow promotes medical ethics. But the factual record in this case shows that an ambiguous statute that prevents physicians from providing the standard of care to patients who want and need that care is in fact contrary to medical ethics, because it creates a conflict of interest between, on the one hand, the patient's interests of getting necessary medical care, and on the other hand, the physician's personal interest of not going to prison. So medical ethics cannot justify imposing an inscrutable standard for when abortion care can be provided to preserve a patient's life or health. And the evidence on medical ethics and this kind of inscrutable law being against medical ethics is in the AMA opinion, that is Exhibit 32 to our opposition, and in Dr. Whittia's deposition testimony, Exhibit 33. The last justification that defendants have proffered is that the medical necessity exception is justified by a need to avoid discriminating against fetuses diagnosed with non-fatal fetal conditions. But for patients diagnosed with fetal conditions, our complaint seeks declaratory and injunctive relief only when that condition is fatal. It is irrelevant whether any of the plaintiffs in this case might wish for a greater scope of relief, but that is not what we are asking for in this lawsuit. Finally, turning to the mental health equal protection claim, this argument actually was made much more straightforward by hearing that the defendants do not intend to challenge Dr. Payne's testimony on this motion, because Dr. Payne's testimony itself explains why and when abortion care is medically necessary to preserve a patient's life or health. Dr. Payne has devoted her career to reproductive psychiatry, and her testimony explains why, for certain patients, an abortion can be necessary for life-threatening mental health conditions to subside. This is at paragraphs 15 to 24 of her declaration, and it also appears at Defendant's Exhibit 12 at our deposition, pages 93 to 94. I can't summarize her testimony completely, but it has to do with the changes to a woman's body that occur with pregnancy, changes in hormonal levels, and so on, which make certain mental health conditions, exacerbate them and or make them more difficult to treat. Her testimony also explains that there are objectively verifiable criteria for mental health diagnoses, just as there are for physical health diagnoses. So defendants' argument that that is not the case, that's certainly not in their statement of undisputed material facts. There is, in fact, no admissible record evidence that contradicts Dr. Payne's expert testimony on the impact of pregnancy on certain mental health conditions. As we pointed out in our opposition brief, the ACOG statement that defendants have pointed to, which again, they did not list in their statement of undisputed material facts, that relates only to the use of medications, certain medications used to treat mental illness during pregnancy. That is hearsay, as Chancellor Moskal pointed out earlier. There is no expert testimony that proffers that statement into court. Dr. Payne's testimony, as I've said, establishes a prima facie case that the exclusion of mental health conditions from the medical necessity exception violates the equal protection rights of pregnant patients whose lives or health are threatened by a mental rather than a physical condition. And I should point out that the defendants seem to misunderstand the the comparison we're making, the premise is that the mental health condition is posing a threat to the life or health of the pregnant patient, just as a physical condition would pose that threat for physical conditions. And the claim is that distinguishing between the two is not rational. The defendant's efforts to say that it is rational are not enough to prevail on summary judgment. First, defendants do not even try to explain why the state's interest in fetal life is greater when a pregnant patient has a life-threatening mental health condition than when she has a life-threatening physical condition. And defendants do not explain how it preserves the medical profession's integrity to deprive physicians of an option that could help them save the lives of patients with mental health conditions. Significantly, as we pointed out in our brief, mental health exclusions to medical necessity exceptions are a recent phenomenon that has no historical grounding. The mental health claim, as I believe we pointed out in our opposition papers, is asserted by the physician plaintiffs on behalf of their patients. It is undisputed that the physician plaintiffs are not psychiatrists, but as they say in their declaration, they work with mental health professionals, and although neither physician would make the diagnosis of when a mental health condition was life-threatening, they do provide obstetric care to patients whose mental health professionals diagnose their mental health conditions. And so they do have standing because this does affect the treatment that they could offer to their patients in conjunction with the mental health professionals who work with them to provide care to those patients. And I believe I am even under the hour allotted to me, Your Honor. So we respectfully request that the court deny defendant's summary judgment motion in its entirety.
All right, I do have a question as to each side about your statements of material facts. And so I'll ask you first, while you are still on camera, Attorney Goldstein.
Yes.
There are several statements of additional material facts to which defendants have objected on the grounds that plaintiffs did not separately state each fact statement, but had several statements that combined your fact statements on the same topic. What is your response to that objection?
I think it might depend upon which statement that is. I think for many of them, the structure was that there would be an overarching statement, and then in the first sentence, and then the following sentences would be the proof for that first statement. That was a general rule we followed. I think it's possible that we might have deviated from that, but if Your Honor could point me to a specific statement, I could address that more cogently.
Well, if you'll give me just a moment. I've flipped my papers a couple of times, so for example, statement of additional material fact number 2, the defendant state it does not comply with Rule 56.03's requirement that each fact be set forth in a separate numbered paragraph and is improper. And then they've said, subject to that objection, they've gone on and responded to it. In this particular case, they assert that the facts are not material, but they're undisputed for purposes of summary judgment. So in those instances where the defendants have gone on to say it's undisputed for purposes of ruling on summary judgment, I think that tends to moot the objection.
Yes, and that paragraph in particular is an example of what I had mentioned, where the first sentence is a summary sentence saying, 4 plaintiffs had fetal diagnoses posing risk to their own health from, in utero death, miscarriage, and or spontaneous early labor. And then the following sentences are, one sentence devoted to each of those 4 plaintiffs that particularizes the facts for each of them.
All right, I just wanted to give you an opportunity, and there are a number of fact statements that the defendants have disputed. Generally, their dispute is based on the cited sources do not establish the fact that's being asserted. I'm looking at, for example, 1213. Your statement of additional material facts, 12 and 13. 16.
Yes, I mean, Your Honor,
And the court can review that and make its determination as to whether the cited material supports the statement or not. But
yes, and we certainly dispute that characterization, Your Honor. And we also believe that to the extent, well, I'll just stop.
and I guess to the extent that it is disputed, for example, I'm looking at number 22, statement of additional material fact number 2. The defendants dispute that, and they cite to Brackney's expert report. Is it your position that that creates a genuine issue of disputed material fact?
Oh, I'm sorry. I'm looking at 22. Am I looking at the wrong document? It's nothing to do with Brackney.
They say statement of the last sentence. You did not cite.
Oh,
Brackney.
I see.
They
Yes.
cited Brackney in their response, saying that they dispute that, and then they cite to Brackney's expert report.
Right. Well, I mean, to the
In your
extent,
view, does that create a genuine issue of disputed material facts?
yes, absolutely. We Dr. Winia and Dr. Brackney
Disagree.
disagree.
Yeah. Okay.
I mean, I would point out that Dr. Brackney is not an ethicist, and Dr. Winia is.
And likewise, in your responses to the defendant's statement of undisputed material facts, there's a number of those that you state are undisputed but immaterial. And so I guess am looking for clarification that you're not contesting that for purposes of summary judgment.
I'm looking at number 1, for
to the
example.
issues.
I'm looking at number 1, for example, where the statement really has to do with the timing of when plaintiffs were denied abortion care. And so there's no dispute as to the timing. The dates are the dates. And the statute was revised when it was revised. But we dispute that there is any legal significance to those dates.
I understand. I'm just trying to confirm, working my way through these many statements of fact to understand what your responses are and to get clarification there. And you have in fact disputed some of these statements.
Yes, we have.
So I'm going to ask, thank you. I appreciate your patience. Did any, in answering
Gave you a
those
lot of paper,
questions,
Your Honor.
there's been a lot of paper. Chancellor Colbreth or Judge Donaghy, do you have any questions for Attorney Goldstein?
I do not. Nor do I.
All right. I am going to allow you, Attorney Adamson. I guess you are going to do the rebuttal.
That's
And I'm
correct,
gonna,
Your Honor.
and I'm going to ask you to limit it to 10 minutes since Mr. Griffin ran over just a bit. But before I receive your rebuttal, I did have some questions. The plaintiffs objected to several of your statements of undisputed material facts because there was no citation to the record, and which is required under Rule 56.03. So I wanted to give you an opportunity to respond to that. And I can give you a few examples if you need them. 30, 43, 44, 53, 54. And I don't know if you have your statement of undisputed material facts handy, but
I'm
those
trying
were
to pull it up, Your Honor.
those are just the ones that I noted.
Yes. So, for example, 30, the challenged abortion statute has not been enforced against physician plaintiff Andresen. You know, as we've argued in our papers, we think it's plaintiff's burden to show that there has been such enforcement. To the extent that the court doesn't think it appropriate to consider that particular assertion, we think that's fine because plaintiffs haven't shown that there's enforcement. So,
Well, I'm not trying to make a judgment call here. They've objected because you have not cited to the record, which under 56.03, if you included in your statement of undisputed material facts, there needs to be a citation to the record. And I just wanted to give you the opportunity to respond. And without a citation to the record, I'm not sure that we can consider that fact.
that makes
Under
sense.
56.03. All right. Anything else you want us to consider with regard to your statement of undisputed material facts, since I kind of jumped in the middle there?
Your Honor, I'll just make the point that especially with any of those assertions without a citation related to enforcement, again, it's plaintiff's burden. There's no dispute of material fact if plaintiffs don't have any evidence of enforcement.
Well, that may be, but if you don't cite to the record that they didn't enforce it, then it's not a fact that the court can take. Oh, okay.
Understood, Your Honor.
We're happy to hear your rebuttal argument, and if we could have this wrapped up in about 10 minutes, that would be great.
Yes, I think I can do that.
All right.
May I proceed?
Yes.
Okay. So to start with, on standing, I didn't hear my friend on the other side respond to our argument that they lack standing to assert their mental health claim. Certainly, it is undisputed that physician plaintiffs do not perform abortions for mental health conditions. So neither patient plaintiffs nor physician plaintiffs have standing to assert the mental health claim. So regardless of the merits of that claim, it must be dismissed. As to whether this court needs to reconsider its prior standing analysis, there has been intervening Tennessee Supreme Court precedent in Wygant by which this court is bound, and Wygant incorporated federal precedent related to the imminence of an injury, and that case law quite clearly holds that past injury plus future fears do not suffice to establish an injury. As far as City of Los Angeles goes, we cited specific references in that case to an allegation that police officers routinely applied chokeholds, just like plaintiffs have claimed here that doctors are routinely denying abortions in an ongoing way. As to physician plaintiff specific evidence, my friend on the other side argued that the record shows they previously provided medically necessary abortion care and that they have denied medically necessary abortion care since the ban went into effect. In their mountain of evidence, I did not hear my friend on the other side mention specific examples of conditions for which physician plaintiffs would provide abortions under Ascension's directives if they weren't afraid of Section 3915-213's enforcement. And that's all that is relevant to Monty's standing. And then as to Andresen, even if her standing is assessed at the time that the complaint was filed before she joined Ascension, we argued that her claims are moot because she has now joined Ascension. So as far as her seeking prospective relief, any arguments that applied to Monty would now apply to Andresen. As to Schlechter's declaration, Dr. Schlechter's declaration about Ascension's practices, I think it's notable that she focuses on the chilling aspects of the statute, not on whether the directives allow abortions in specific cases that the statute would otherwise not prohibit. And that's what we have argued is relevant to the first prong of the pre-enforcement injury inquiry. As to enforcement, I heard my friend on the other side rely solely on the board's statutory authority, plus a new enforcement argument that was not raised in their response brief about the ability of people to file complaints, making the statute more easily enforceable. But in 4 years, there have been no complaints. So that actually cuts against plaintiffs. As to the Attorney General.
So I have, and I know I'm cutting into your time, but I do have a question that really troubles me.
Okay.
When we have a criminal statute on the books that is deemed a felony, subject to up to 15 years incarceration, loss of license, and the board has mandatory authority to take disciplinary action, your argument seems to say, well, there's been no effort to enforce it. Therefore, what do we do? Are the physicians allowed to ignore the abortion ban? Are they, just because it's not, what is a law that's not being enforced? Is it a nullity? Where does that leave us? And, kind of from a broader perspective, society could really run amok pretty quickly if all the laws that maybe weren't being enforced could be ignored and say, well, they can't be challenged because they're not being enforced.
So respectfully, Your Honor, two responses to that question. So one, the law is very clear that even in the criminal context, a plaintiff has to show a credible threat of prosecution. So that we're not taking an outlier position here. This is a rule that is applied in every criminal context, even with criminal statutes that have much more severe penalties than this one. The second point is to your Honor's more sort of practical point. I think the court might take a look at the Sixth Circuit's opinion in Friends of George's, where the court, in dismissing, in holding that the claims should be dismissed on standing grounds, the court reasoned that the conduct that the plaintiffs wanted to engage in there was not prohibited by the statute. And we have made a similar argument here that there's no evidence of enforcement against these physician plaintiffs in the specific cases they have presented. Now, of course, that wouldn't apply under this statute to the instances that are clearly prohibited by the statute, such as abortions for mental health conditions, or in the case of fatal fetal anomalies, or life-limiting fetal anomalies. But that might be a way for the court to assuage some of its concerns about this statute's application in future cases, even in the absence of the enforcement evidence that is required to show a credible threat of prosecution.
Please proceed.
Okay, thank you, Your Honor. Okay, so I think I had gotten to the Attorney General. Again, I think this cuts against plaintiffs here. It's been years now since Davidson County's DA said he wouldn't enforce Section 39-15213, and the Attorney General has not exercised his pro tem authority. And then on mootness, the may include language accounts for a physician judgment. We've explained how it does that. I think a very helpful example is it accounts for a case like severe preeclampsia that often occurs at very late stages of the pregnancy when it wouldn't be appropriate for a physician to abort the baby. Instead, if the mother was at 34 weeks and developed severe preeclampsia, the appropriate step for the physician to take would be to deliver the baby. So that's one instance.
Is that in any of your expert testimony?
Your
That
Honor,
statement you just made that it would be more appropriate for the physician to wait, or excuse me, to deliver in late stage preeclampsia. Do you have expert
sure, Your
testimony to that?
Honor.
Okay.
We would be happy to double check and look. But I don't think plaintiffs would object to that understanding of how to treat severe preeclampsia.
Well, on motions for summary judgment, and I say this to both sides, we are limited to the record. We are limited to what the parties have put in front of us, what statement of facts are presented, what expert statements are presented, how they're responded to. And, I think we've been forgiving in arguing, making some arguments that go beyond those facts. But in our review of the summary judgment motion, we are strictly limited to what's in the record.
Yes, Your Honor. And I would not be surprised if Dr. Brackney discussed this in her deposition, but I just don't have the site at my fingertips. The point is, though, that the court is required to apply the ordinary meaning of the statute and construe it in a way to uphold the law. And that's just one way to see how the may include language applies, potentially. On the right to life point, I told Your Honor that I recalled but didn't have a site for specific record instances where plaintiffs have admitted that it's clear that a physician may perform an abortion to save the mother's life. So those are Defendants Exhibit 7, Monty's deposition, page 138. Question, do you think that the law makes ending any pregnancy a felony offense if it threatens the life of the mother? Answer, no. And then Defendants Exhibit 13, Zuckerwise deposition, pages 196 to 197. Can you think of any instances, ellipses, where it would be clear that the medical necessity exception applied? A patient with PPROM who's overtly infected. That would be an instance where an abortion would be necessary to prevent the woman's death. Answer, death or major complication or loss of fertility. So plaintiffs have admitted in the record that it's clear under the statute that that physicians can perform a life-saving abortion. And I would also point out that their challenge is not as narrow as they have characterized it. Physician plaintiffs have both testified that pregnancy poses a threat to the mother and that abortion is always indicated, at least pre-viability, if the mother requests it, even when the baby, excuse me.
You need to get a drink. Go ahead, please.
Thank you. A lot of dogging. They have testified that an abortion is appropriate even in the case of a Down syndrome diagnosis.
No problem.
And the prayer for relief, paragraph A, asks for abortions to be available under the medical necessity exception for medically necessary abortions, which, as you heard today, plaintiffs think includes abortions for life-limiting fetal anomalies, even when there's no risk to the mother. Very quickly on the two equal protection claims, my friend on the other side is wrong as a matter of law that the court cannot uphold the law based on a conceivable rational justification, even if plaintiffs or the court would have balanced the interests differently. And we cited 5 cases, Tennessee and federal, in support of that proposition at page 48 of our summary judgment brief. On mental health, the key point here is plaintiffs can't dispute their own maternal fetal medicine specialist's opinion that abortion, quote, is not the treatment of a mental health condition. And Tennessee and the US Supreme Court recognizes that it is rational for the legislature to take one side of a medical debate. So even if that's debated in the record, the state has taken a rational position and the state is entitled to summary judgment, even if plaintiffs had established standing on that claim, which they haven't. Lastly, on vagueness, plaintiffs still haven't pointed to Tennessee case law saying that you can assert an as-applied vagueness challenge before a criminal statute has been applied. And Crank makes clear that a criminal statute does not have to list all potential applications to avoid constitutional vagueness. Physician plaintiffs just fundamentally miss the point of an as-applied vagueness challenge. The court must look to whether the law is unconstitutionally vague as it applies to their specific practice, not the practices of others, especially others who are not bound by Ascension's Catholic directives about abortion. So for those reasons and the others we have advanced today and in our briefs, Your Honor, we would ask for the dismissal of all of plaintiffs' claims on justiciability grounds or summary judgment on the merits. Thank you, Your Honor.
All right, thank you. That concludes the oral argument on defendant's motion for summary judgment. The panel, as I said at the outset, will take this motion under advisement to give the panel the opportunity to confer and prepare a ruling. The court, as the parties are aware, the case remains set for trial, and we will continue to move forward to that trial date. Any questions, anything else we can address? Attorney Goldstein?
Well, I would just point out that some of the factual references in my friend's rebuttal statement do not appear in defendant's statement of undisputed material facts, and we would submit cannot be considered by the court on the pending summary judgment motion. But other than that, I had nothing further to add, and I look forward to seeing the court in 2 weeks.
Attorney General Adamson, you get the last word. Would you, if you want to respond to Attorney Goldstein on the argument?
Your Honor, I'm not sure which references Ms. Goldstein is referencing, but
we're not going to get into that debate at this
exactly.
juncture. The court,
yes, Your Honor,
as I think I indicated, the court is going to review the record very carefully and make a determination whether the facts are supported by the evidence that has been submitted. All right. Anything else? Attorney General Adamson.
Nothing from state defendants.
All right. Very good. That concludes this hearing. You are all excused. You may leave the meeting. Thank you. Have a good evening.
Thank you, Your Honors.